Hey everybody. I'm going to diverge a little bit from my normal video format to update everybody on the research that I've been doing and some of the discoveries, which one leads to the other, and as a result I haven't really been able to do any videos or write any articles for a bit because following the rabbit hole. So recent discoveries started out with my decision to look into the case of Karla Homolka. For non-Canadians, most Canadians know who Karla Homolka is, but for non-Canadians, Karla Homolka struck what is referred to generally as a pact with the devil with the government and prosecutors over a crime that involved the deaths of two teenage girls who were abducted, sexually tortured, and then murdered. Ultimately, the name attached to those murders officially was her husband at the time, Paul Bernardo, but it came out after her deal to give evidence against Bernardo was struck that Karla Homolka participated almost joyfully in the torture of these girls, herself participating in it. When this came out during Bernardo's trial, 2 years after Homolka was sentenced to only 12 years for her involvement and her confessed involvement, it became evident that her confession fell a little bit short of the truth. So the Canadian public was outraged, has continued to be outraged at the name Karla Homolka, and considers it one of the most gross miscarriages of justice in Canadian legal history. Homolka's case, when you look at it, there is a chief of police who says that they didn't investigate the murder of Homolka's sister, which was deemed at the time to be an accidental death, but as it turned out, was actually a rape and murder conducted by both herself and her fiancé at the time, Paul Bernardo, that they didn't exhume the body or investigate too thoroughly because he was informed that there would be no charges pressed, so it was a waste of resources and time. And he claims he was told this by the prosecutor. The prosecutor stated that she was not satisfied with the outcome of the trials and only 12 years given to Homolka, and that there were other ways that the case could have been dealt with. So if it's not the police officer and it's not the prosecutor, then you have to wonder who was it. As it turns out, it was the Attorney General of Canada who was making the calls and the decisions on how to handle the case. The Attorney General of Canada at the time was a known radical feminist named Marion Boyd. Marion Boyd, on top of being a radical feminist, was the only Attorney General in Canada to ever be appointed who did not have a law degree. Now there's a lot of information that I've encountered that I would like to convey, so hopefully you can sort of bear with me and stick it out because it gets really interesting, and I will be doing more videos and writing some articles about this. This is basically just an update on what I've been working on. So we have the Karla Homolka case. There is further involvement by feminists in the Karla Homolka case. Despite the outrage of the Canadian public at the lenient sentence, 12 years is kind of an odd time. What actually happened was Homolka was given 10 years for her involvement in the murders of Leslie Mahaffey and Kristen French, which were the schoolgirls being investigated, which led to her confession, and she felt they were getting close to finding her out, so she offered her own information. So she got 10 years for each of those involvements, but they were concurrent, so her total sentence was 10 years instead of 20. And then when it came out that her sister had been murdered as well, they tacked on 2 years for Tammy, which was her sister's name. But she was never actually charged with her involvement in Tammy's death. So it's called 2 years for Tammy. And she ended up with 12 years. And before those 12 years were up, a couple of things happened. Photos were released from the prison which she'd been transferred to, Joliet, and those photos showed that she was actually not having that difficult a time in jail. She was shown in party dresses during a birthday party held for one of the other inmates, and other various things that led to her being called the party girl. She went to a psychological assessment to see if she would qualify for parole or early release. She was not deemed to be suitable for that by the psychiatrist because, for among other reasons, she continued to show no remorse for her part in the crimes. As the parents of the dead teenagers have offered in evidence to her assessments. They never received a single letter from her showing any sort of sympathy or apologies or anything like that. Despite this, an organization called Elizabeth Fry Societies tried to assist Karla in getting an early release under their care to a halfway house. The parents of Mahaffey and French stated that it was obvious that the Elizabeth Fry Societies and the person speaking on their behalf had no idea about the case and seemed to not have a clue what she was talking about. So who are the Elizabeth Fry Society? It's a group of organizations. I believe there's 25 of them, and then there's the parent organization, the Canadian Association of Elizabeth Fry Societies. Their name is taken from a woman named Elizabeth Fry from England who sought to get prison reform to make conditions for prisoners more humane and hospitable, and to try and help rehabilitate them as opposed to just punish them. It seems like Elizabeth Fry had her head in the right place, she had good ideals, and her name is being used by the Canadian Association of Elizabeth Fry Societies now, who have a very, very narrow mandate not to improve the lives of prisoners, but only to improve the lives of women prisoners. They have a type of rhetoric they use that involves phrases like the criminalization of women. When I first read that, I started laughing in disbelief, because what they're actually talking about is women who've committed crimes, but they're not saying that these are women guilty of crimes. They're saying these are criminalized women. If you look at that statement, women are being criminalized, and think about the use of words here. To criminalize women, you're not talking about criminalizing an act or a substance like marijuana. You're talking about criminalizing a gender, which means that she is accusing Canadian society of finding women, by nature, by gender, to be criminals. And that is absolutely absurd. There is no way that that statement makes any sense or applies to reality in any way, shape, or form. So yet again, like in the Karla Homolka case and their arguments for Homolka's early release, you are looking at a woman, and if you go to their site, you can listen to a woman who seems to have absolutely no connection to reality. And yet, they are successfully changing the way the laws of Canada are applied. If you follow this further, it goes back to the Canadian Charter of Rights and Freedoms. This was formulated in 1982. It was adopted into Canadian law, and it expanded the powers of the courts to make decisions about human rights and whether or not laws should be struck down based on violations of human rights. At the time of its drafting, there were lots of lobby groups involved, and they generally got their way. Feminists were one of those lobby groups, and in fact, the Women's Legal Education and Action Funds have been very, very involved with the Charter of Human Rights. LEAF is the #1 intervener in Supreme Court cases in Canada, and they are known to almost always win their case. Funny enough, one of their big cases at the beginning involved Andrews versus the Law Society of British Columbia. It was actually a man who was not from Canada, who was challenging that he wasn't allowed to practice law in BC because he was not a citizen of Canada or of BC. And so he challenged that on the Constitution and won. And LEAF was extremely interested in seeing him win. But Women's Legal Education and Action Fund, do you think that they actually cared about the outcome of a case for a man wishing to practice law? Not at all. LEAF is very, very focused on shaping the way the Charter of Rights and Freedoms can be used to help get women off of murder charges, in order to get women out of jail, in order to get women anything that makes their lives easier and keeps them from being held accountable to Canadian law. I've come to the recent decision that feminists would like to see 2 sets of law in place. They would like, actually 3. They'd like to see white male laws, which is how they look at the current system of the criminal code, right? They see it as the status quo is what they call it. It was designed by white heterosexual males to serve the needs of white heterosexual males. And they are quite happy to see that criminal code applied in cases of rape or domestic violence. Violence against women is their phrase for it. They have no problem with the current system of law, and they want to see it applied more vigorously. But what they seem to want in substantive equality is a second set of laws that apply to women, because women apparently have a unique position in the society that is keeping them constantly oppressed. Women are incapable of breaking out of this oppression, incapable of making their lives better, and therefore must need a second set of laws that doesn't hold them as accountable for their actions. And they also would like a third set of laws that applies to Aboriginals. And that's not an argument I want to get into, because it's much deeper, and I'm not an Aboriginal, so, what am I allowed to say about it? Right now, you pretty much can't talk about anything unless you belong to that group. I happen to be a woman. I'm quite comfortable criticizing feminist groups who claim to speak for me. I don't want the globe to think that I am one of those sick Canadians who thinks that murder is okay if you're female and you're killing a man. So that's pretty much an update on what I've been looking into. It's an introduction of a couple of new characters to the ongoing research that John and I have been doing into Elizabeth Sheehy and Women's Legal Education and Action Fund, or LEAF. I'm now adding the Elizabeth Fry Societies to that list, Kim Pate, and I'll be interested in finding out more about Marion Boyd, the only Attorney General in Canada, radical feminist, who did not require a law degree for her position. So hopefully I'll be making another video soon. I've definitely got some articles set to be written, and the biggest problem at this point is that there's so much information I've encountered. Trying to figure out where to start is the biggest problem. So this video is pretty much my start, and expect a lot more from me on all of these issues, and I'll talk to you soon.